Start. If the above noted order is deciphered, comma, it indicates that the amount to be deposited was voluntarily offered to be done on behalf of the appellant. Full stop. Since obviously the learned counsel for the respondent had taken notice just then and no submission on his behalf has been recorded, the respondents at that stage had not played any part. Full stop. Further, comma, there is no indication that the court had insisted for the deposit. Full stop. It is no doubt true, comma, it is however indicated in the order that the said suggestion was accepted as a fair one by the court, and it was also observed that the question of the refund of the amount with interest would be examined at that stage in case the petitioners succeed in the petition. Full stop. If the said aspects are kept in view and the nature of the issues raised before the High Court in the writ petition is taken note of, comma, the prayer in the writ petition was for quashing the demand dated 9/3/2010, raising the demand. Full stop. The basis to challenge such demand is also due to the fact that the notification dated 10/10/2008 and 23/12/2008 issued by the respondent, due to which such demand was raised, was also assailed and sought to be quashed as not being sustainable. Full stop. Therefore, comma, it is evident that the quashing of the demand for the amount would only follow if the notification imposing the additional FAR charges was quashed by adjudicating it to be unsustainable and consequently the demand not being in accordance with the law. Full stop. Pending consideration of the adjudication with regard to the validity of the said notifications dated 10/10/2008 and 23/12/2008, comma, the respondents through a subsequent notification dated 17/7/2012 had exempted certain categories from the imposition of additional FAR charges and had indicated in the said notification that the other contents of the notification dated 23/12/2008 will remain unchanged. Full stop. Since, comma, through the said notification the benefit was available to the writ petitioners, comma, the writ petitions insofar as the challenge to the notifications dated 10/10/2008 and 23/12/2008 not being necessary to be considered on merits had been disposed of, and the amount which had been deposited was directed to be refunded. Full stop. Therefore, comma, in the present facts, as on the date when the writ petition was filed and the petitioner had voluntarily offered to deposit the amount, comma, the amount was to be paid and recoverable under the notification dated 10/10/2008 and 23/12/2008 if the benefit of additional FAR was to be availed. Full stop. The petitioners being desirous of availing the same and to proceed with the construction on obtaining the sanctioned plan had proceeded at single inverted comma breakneck single inverted comma close speed and had incurred the expenditure by offering to deposit the amount and avail the benefit instead of awaiting adjudication and thereafter availing. Full stop. In that view of the matter, comma, when as on the date the deposit was made, comma, the notification remained valid and even subsequently there is no declaration that the notification and the demand made is illegal, comma, but through the subsequent notification an exemption has been granted by the respondents themselves to a certain category of institutional plots to avail additional FAR without levying such charges, comma, it is not the case where any of the principles as enunciated in the above noted decisions would apply herein. Full stop. As noted, comma, the circumstances in which the deposit was made is not in a situation where the appellant has suffered any loss due to the single inverted comma act of court single inverted comma close in the sense it ought to be construed. Full stop. Further, comma, insofar as the respondent is concerned, comma, the notification providing for additional FAR charges was in force on the date when the deposit was made. Full stop.